Good morning, friends. Today I am going to discuss about the topic legal aspects of marine insurance. So, marine insurance is an agreement whereby one person called insurer or underwriter agrees according to specific terms of contract to indemnify another person called assured for the losses incurred in connection with the property such as ship, goods, or other movables in maritime transport. So, this marine insurance covers the physical losses or damages of ships, cargoes, terminals, and any transport by which the property is transferred, acquired, or held between the points of origin and final destination. In India, marine insurance is governed by the Marine Insurance Act 1963 and it introduced in India on 1st August 1963. This Marine Insurance Act extends to the whole of India. It plays a crucial role in safeguarding the interest of insured parties, and all stakeholders involved in maritime trade and commerce. Under this Marine Insurance Act 1963, marine insurance is defined under Section 3 as an agreement whereby the insurer undertakes to indemnify the assured in the manner and to extend thereby agreed against marine losses, that is to say, the losses incidental to marine adventure. It protects against the losses caused by marine hazards or perils of the sea. These are some of the pictures like damages happens to the containers, explosion fire happening on the ship, sinking of the ships, also the destruction like heavy storm, rainwater damage, etc. So next we are going to discuss about the marine insurance policy. So this marine insurance policy is a document which embodies all the particulars and the terms and conditions for the construction of the policy. So this contract of marine insurance shall not be admitted in evidence unless it is embodied in the marine policy in accordance with the section 25 of Marine Insurance Act. This policy may be executed and issued either at the time when the contract is concluded or afterwards. So next we are going to discuss about the types of marine policy. So mainly there are different types of marine policy such as time policy, voyage policy, mixed policy, named policy, port risk policy, valued policy, unvalued policy, single vessel policy, fleet policy, blanket policy, block policy, and floating policy. So, in time policy, the subject matter is insured for a definite period of time. It cannot be for a period exceeding 1 year because it will be invalid, but it may contain a continuation clause. Continuation clause means that if the voyage is not completed within a specified period, the risk shall be covered until the voyage is completed or till the arrival of the ship at the port of call. Second type of marine policy is voyage policy, that it coverages for risk to the ship's cargo during a specific voyage. It is not time based, but it expires when the ship arrives at its destination. It covers only the cargo, not the ship that it carries. In mixed policy, from the word itself, we can understand that it is a combination of both voyage policy and time policy. In mixed policy, it covers voyage taken between specific destinations during a specific period of time. And in named policy, one of the most popular policy in marine insurance policy is named policy. The name of the ship is mentioned in the insurance document stating the policy insured is in the name of the ship. In port risk policy, this policy is taken to ensure the safety of the ship when it is stationed in the port. And in valued policy, it specifies the agreed value of subject matter insured between the insurer and the insured, and it is specified in the policy itself. In unvalued policy, here it does not specify the value of the subject matter insured. In single life policy, from the word itself, it is for the ship owners who only own for one ship. And in fleet policy, it is the ship owners who owns multiple ships. Blanket policy says that the owner has to pay the maximum protection amount at the time of buying the policy. In block policy, it covers transportation of goods both by land as well as sea. And in floating policy, it is a policy for business that transports frequently. Next, we are going to discuss about what all things that contains in marine insurance policy. It contains name of the assured, subject matter insured, and the risk insured against, the voyage or period of time, or both as the case may be covered by insurance. The sum insured, sums insured, the name or names of the insurer or insurers. Also the signature of the insurer. In this marine policy, it must be signed by or on behalf of the insurer. Next, we are going to discuss about what all documents required for the claiming process of insurance. And to make the claims under marine insurance and be able to reap the benefits, the correct document should be submitted. In case of any lapse, there is a chance of the risk being rejected. Some of the documents needed are duly filled in claim form, original insurance certificate with the policy number, copy of bill lading, survey report or missing certificate, original invoice, packing list, shipping specification, copies of correspondence exchanged. Next, we are going to discuss about what all steps or process for claiming the insurance. So, after purchasing the marine insurance, in case there arises a situation when you need to make a claim under the policy, you can follow these steps such as notification of loss, documentation and assessment of damage, survey and assessment, claim review, quantification of loss, settlement offer, negotiation and agreement, payment, etc. So in first step, notification of loss says that it is a process of informing the insurer that the accident has occurred. So the notification should be made as soon as possible after the incident occurs. So it immediately inform the insurance provider about the date, time of the incident, the location, and the nature of the damage or loss. So the second step, documentation and assessment of damage. Here all the proofs and witnesses need to be submitted, including with the photographs, videos of the damage, as well as any other relevant evidences. And in third step, survey and assessment. Here a surveyor will assess the damage or loss mentioned. In many cases, the insurer will appoint a marine surveyor to assess the extent of loss or damage. Here, surveyor's role is to investigate the circumstances surrounding the incident, inspect the damaged goods or vessels, and provide an independent assessment of the claim. The surveyor's report is a critical factor in determining the validity of the claim. This step is to review the claim. The insurance claim department will review the submitted documentations and the surveyor's report, comparing the information with the terms and conditions of the insurance policy. If the claim is valid and falls within the policy coverage, the insurer will proceed to the next steps. After that, quantification of loss is done. Once the claim is approved, insurer will calculate the amount of compensation owed to the insured party. The settlement amount may include the cost of repairing or replacing damaged goods. After that settlement offer, the insurer will make a formal settlement offer to the insured party. This offer outlines the amount to be paid to the insured along with the terms and conditions associated with the settlement. The insured can either accept or negotiate the offer. The next step is negotiation and agreement. If the insured is not satisfied with the initial settlement offer, negotiations may take place to reach a mutually acceptable agreement. And the last step is the payment. Once the insured party accepts the settlement offer, the insurer will process the payment promptly. The insurer will receive compensation for an agreed upon amount. So the next slide says that there are some of the exclusions in marine insurance. So the marine insurance has various kinds of coverage for the benefits of all. However, the policy does not cover certain situations, and that's called exclusion. Some of these cases are willfully planned or intentional misconduct, strike, rioting, war, poor packaging, quality of cargo, delays, general leakage or wear and tear of the cargo, financial distress or insolvency of the shipping line, removal of their work. These all are some of the exclusions in marine insurance. We are going to discuss about the various types of marine insurance clauses. So mainly there are three clauses such as clause A, clause B and clause C. Clause A says that it is maximum coverage. It covers losses due to breakage, chipping, denting, breaching, theft, non-delivery, all water damages, etc. This clause A also covers clause B and clause C. And second type, clause B, says it is an additional coverage. It covers the shipment against events such as earthquake, volcanic eruption, damage due to rainwater, seawater, river water, etc. And this clause B also covers clause A. And last one, clause C. It is the basic coverage. It covers the shipment against events such as fire, discharge of cargo in case of distress, explosion, accidents like sinking, capsizing, derailment, collision, etc. So guys, it's time to end up our section. So here we discussed about what is Marine Insurance, Marine Insurance Act 1963, Marine Insurance Policy, types of Marine Insurance policies, documents required for claiming process, steps for how to claim the insurance, marine insurance, and also the some of the exclusions coming under marine insurance. And at last we discuss about the various three types of marine insurance clauses. So guys, thank you. Have a nice day.